Hi, welcome everyone. So while we are still waiting for some people to join, I will just briefly remind you what we do as Ideas, the company. So I hope everyone can see the slides right now. And on behalf of Ideas, I would like to welcome you all to the webinar. Today's topic is about AI and data science in the world of IP with PJ Yedidsion. Ideas wants to thank you all for joining us today, and we hope that those who are watching the video on our YouTube can join us next time. So before we begin, we would like to briefly go over what IDEAS is about. IDEAS stands for the International Data Engineering and Science Association, and it is a nonprofit organization based in LA, California. Our mission is to bridge the gap between academia and industry. Our data engineering and science hub provides robust resources and connections with real-world expertise from business leaders, professionals, and promising students. Our vision is to foster the data engineering and data science ecosystem and broaden the adoption of their technologies, thus introducing innovative technology to society. So now to hand it over to Mr. PJ Yedidsion.
Thank you, Emily, and thank you everyone for joining us today. I will try to make this as useful and informative as possible. As Emily mentioned, I'm Pejman Yedidsion. I go by PJ. I am a patent attorney at the law firm Concept IP LLP. I have a bachelor's in science in computer science, and I worked as an engineer for about 6 years, while I also went to law school and got my JD. And currently, our firm is solely focused on intellectual property law, patent law in specific, and we work with a lot of technology companies to file and obtain patent and patent protection in the US and in other jurisdictions. And so with that, I will begin the presentation in AI and data science in the world of IP. A quick overview of some of the areas I will cover today. One of the things that would be useful, I'm sure to a lot of people, it might be repetitive, but we'll go over some basic definitions. We'll talk about some of the impact that AI has had on IP law and in general. We'll then discuss some of the state of the patent eligibility with the United States Patent and Trademark Office and the court systems here in the United States. Then we'll specifically go into some software-specific patents and which relates directly to AI and how what is necessary for filing such patent applications and securing them. And finally, we'll just talk about some patent strategies, what type of applications to file, what is useful as far as getting patent protection, and what a company and an organization can do in order to maintain a patent portfolio and protection around the R&D and the money that they're spending on their developing new software and in particular AI applications. So this is everyone already, I'm sure everyone that's watching already knows this. What is AI and data science? So artificial intelligence is defined as something that is done by computer to do tasks that are usually done by human beings. So, you know, it's not necessarily that it's anything separate from software. It's pretty much software running on a computer that is doing tasks that are perhaps done by humans or require human intelligence to get accomplished. A subset of AI is machine learning, and that allows software applications to become more smart smarter by using historical data and be able to provide better results. As far as data science is concerned, it just uses scientific methods to extract knowledge from big data, they call it now, where you have structured or unstructured data, and it requires a lot to go through and acquire knowledge and information from that data, and to be able to process that data. Next, we'll talk about what is a patent. At its core, a patent is a property right. It's the right to exclude others from making, using, selling, offering for sale, or importing what the patent is claiming to be the invention. Patents have a limited term, and they are per territory. So there's no one patent that covers multiple jurisdictions. It's per country. Even in Europe, as everyone might knows, UK has separated from Europe. So now Europe has its own patent system, and UK has set up their own patent system. So every country has their own examination of the patent and their own rules, and specific to probably what the local courts have come up with, and what holdings they've had. As far as different types of patents, there are design patents, utility patents, and plant patents. I don't think anyone really here wants to know about plant patents. Design patents cover ornamental features of a particular invention, but again, we won't need to go into that. So there's different types of utility applications. We have machines, articles of manufacturing, processes which software and therefore AI falls under, and compositions of matter, which is pharmaceutical type inventions and patent applications. And again, we're going to concentrate more on the different processes which fall under the software patents. The code, this is a US Code 101, specifically says that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent therefore. And there's some requirements, we'll go over that later, but obviously your idea has to be novel. One of the other requirements that it has to be unobvious. And so those are the basic blocks of what's going to be defined as a patent. Now, switching over to AI and the impacts of AI. And this is a very general, broad classification of it, but some impacts of AI on human beings. As everyone knows, recently human creators are increasingly being assisted by intelligent technologies. We're using AI to help us solve problems, either with their help, or as some cases recently is entirely left to the AI programmed computer or software program to solve specific problems on our behalf, which brings up some interesting questions, which I'll go over in the next slide. But as far as AI and how it connects with the world of IP, IP systems have been designed to incentivize human innovation. So the whole thing is you come up with an idea, you disclose it to the world. In return, you get patent protection, and potentially you get to license that idea or license that patent to someone else to use it. And so by default or by definition, a patent has to be able to describe well enough what the invention is for someone else to be able to use, to pick it up and read it and be able to pretty much reinvent that, what the invention was, to reproduce the invention. So it's based on an incentivization system that if you create something, you can get protection for it by being able to prevent others from using the same patent or the claimed invention. Until very recently, such innovations and creations was one of the defining characteristics of human species. So, obviously before AI and computers became so smart, there was only human inventors. There was nothing else, and every application had one or more person named as an inventor on it. Now they could assign their rights to the company, but no matter what, we have a human being involved as part of this innovative or creative idea. So, and again, as we'll touch upon it later, the question now is, how do we balance the human inventions versus creations that were made by AI innovations? And the impact of this will be that whether an AI computer or software can itself be an inventor. We'll talk about that on the next slide. And the other part is, how do we incentivize human beings still? Because if AI is named as an inventor, how do we get human beings to feel like, okay, I'm going to invent something and prevent someone else from using it? Whereas technically an AI software, even if they get a patent granted to them, they probably won't have the ability to communicate with an attorney to go sue a potential infringer for infringing their patent. And so that becomes a whole area that's very recently become a big topic of discussion. And as we'll talk about in our next slide. So inventorship and AI. At the core of it, inventorship is whomever invented the invention, right? Whoever came up with the idea. Now, we have, again, recently AI generated works, which are defined as output from an AI, or I guess who can substitute AI and software for each other mutually. But it's a work that traditionally a human has done, but now it's coming a functionality of an AI software that is able to do the same type of thinking or the same type of analysis on a particular problem. There is a recent case, actually very recent, just I think literally a week ago, that raised the legal question of whether a patent can be obtained by an invention created by an AI software in the absence of traditional human inventor. They call that an AI generated invention. So far, the USPTO and the courts, this hasn't gone too high up. It's recent, but so far, everyone has been of the idea that AI machine is not entitled to patents. And so they've pushed back on this argument that an artificial intelligence device can qualify as an inventor. One of the reasons that has been given here is that conception of an idea by statute has been defined as, as you see here on the slide, a complete performance of the mental part of the inventive act. And so the mental part is in the mind of the inventor. And I think when you look at it, if you just go by the words, it's how can an AI software have mental steps in their head? And so that's one reason this case, Townsend, hasn't had much success, in that the USPTO and the court have said that there's no in AI that can be an inventor. There's no connection with each other, and that you need a human being listed on that patent application as an inventor for it to move forward in the patent process and to be granted a patent. So with those questions in mind, I'm going to go on to talk about software patents and a little history of it. It's been 10 years now, almost 10 years, 8 years, in a case called Alice versus CLS Bank. The Supreme Court actually questioned the validity of software patents because that particular application was for, as CLS Bank had invented or had created some software, business method software, that was balancing checkbooks between accounts. And actually one of the justices' question was, why should this be a patented idea? Because I've been balancing my own checkbook for years. People have been balancing checkbooks, and just because now it's been programmed into a computer to move money around between accounts, why should that be a new, innovative, unobvious, and non-abstract idea? And that's where this whole abstract idea thing came from, where the Supreme Court came up with a two-part eligibility test to see if software patents qualify for patent protection. Now, I'm not going to go into too much detail, but the test at its at the high level requires determining if an invention involves an unpatentable abstract idea. At the end, this whole abstract idea, a natural phenomenon or a law of nature. Obviously, the patent office does not want to grant any patents to anyone to get any monopoly on any sort of laws of nature, any ideas that are, as they call it, abstract, where it's not necessarily that anyone could potentially at any time be infringing if they get this such a broad monopolized patent to a particular company or a person. So what they came up with is if it is part of that, then the next question is there an inventive concept that comes with these claims as part of the patent application? So in that case, they actually invalidated the patent, and they said just moving money around did not have an inventive concept or an inventive step, they call it sometimes, in order for for this to be beyond merely a well understood routine and conventional thing to do on software or on a computer that humans could have done in their mind or with a pen and pencil or paper. A couple of years later, in another court case, but this one at the Federal Circuit, the Enfish case, as the court took the one sentence out of Alice as the legal foundation for approving more software patents, and that sentence, or that became sort of the legal foundation, was known as the technical effect doctrine, which holds that software that improves the functioning or functionality of a computer should be eligible for a patent and considered patentable subject matter. With that, and we're going to dive into this in the next few slides, it opened up the thinking, and also it opened up the idea that if the software, which again, AI and software go hand in hand, is able to improve the functionality, make a difference in how the computer is functioning as far as processing power, memory usage, the list can go on and on. It would be patentable subject matter. And I believe that particular case was about, and I hope I'm not mixing it up, but it was a case where it was the company had developed software for antivirus software where they would take what they thought was potential malware and move it into a particular space in the memory and block it from the rest of the data and the rest of the computer in order to protect it, and then go back and try to eliminate that particular malware. So that was found to be patentable. And like I said, we'll go a little bit more into details as to what is abstract idea and what we need to do in order to be able to patent an AI related invention. So non-patentable subject matter, as I mentioned, is an abstract idea. Mathematical concepts, organization of human activity, mental processes, things that, like I said again, it's human beings can do, and it's part of everyday life. And I think this court and the USPTO's objective is not to give any patents to someone that could hinder everyday human being, activities of the human being race. Just because then now you have people suing everybody and saying that everyone's infringing their patent because they took steps to go in an elevator and go downstairs, those kinds of things. So the test, that we talked a little bit, as far as the technical improvement to a computer. And they're saying that it's not just an improvement to how the result was accomplished, but more an improvement to the computer's functionality. And that's not an abstract idea. So going back again to the functionality of the computer, if you're able to reduce processing power, reduce the use of memory, reduce the speed by which you can return a result. Again, all of these have a direct connection with AI. Those can be patentable. Now, just as of this last Thursday, there was a case, not AI specific, but there was a case called American Axle that went up to the Supreme Court, and the Supreme Court essentially turned it away. They declined to rule on it. And this patent was about quieting a drive shaft noise, where everyone was thinking, okay, the Supreme Court is going to pick this up and clarify what really warrants a patent and what is patentable subject matter. This had actually been rejected by the USPTO and all the lower courts. But American Axle still wanted to see if they can get a patent on this method of manufacturing of a drive shaft, which reduced vibrations. But ultimately, again, because the Supreme Court didn't pick it up, it's invalid due to the fact that it's an application of a physics principle called Hooke's law. And going back to that method of human organization and activity and mathematical concepts, that falls under that scenario. Now, applicants should. So, how do we not fall into the same trap, or in a patent application for AI specific inventions? What's needed? So, as of now, again, because there's no more clarity, we're going with that applicants in their patent applications should include technical benefits of the invention and focus on specific asserted improvements on the computer's capabilities. So like I mentioned, the particular AI, by doing X, Y, and Z, is able to reduce the use of processor memory or time, anything that's an improvement on the capability of the computer, even if it's a general computer. So a little bit more specific, to go into patents on AI and even data science type inventions. So far, again, without this, now that the Supreme Court did not pick up this particular application, or I'm sorry, appeal from the lower court, what we know so far is that algorithm-based inventions, software-based inventions, and computer-implemented methods are patentable subject matter. Now, data manipulation and manipulation of data is technically not patentable subject matter. So collecting data and just sorting it slightly differently or accessing the data is not considered to be patentable subject matter based on the cases we've seen so far. However, using that data to improve the functionality of a computer or system is considered patentable subject matter. I can give one example of my own client where they improved the search speed of a particular database that's set up. I don't want to give too much away, but they had come up with a way of connecting to someone who was looking for funding and someone who wanted to fund particular projects, but it would take too long for these two to find each other. And it wasn't that he just came up with a database for people to go look and be able to say, oh, this person might be able to invest in my company. It was that he came up with some way, a method of binding the data together in order to be able to return the results in a faster and more efficient manner. So that actually was found to be patentable. We got a patent for the client, and so it at the core of it comes down to the fact that it's finding a way to improve the functionality of the way the computer is executing. So switching over specifically to AI and AI innovations. Obviously, these two things, AI at its core improves its own or other technology areas or technical fields, and also improve the functionality of a computer itself. So by definition, anything that falls on, now these are not all inclusive. There's other areas, of course, but just looking at these two things where there's improvements to a technological area or improvements to the function of the computer, automatically we've seen court cases and we know that the USPTO allows and accepts these as patentable subject matter. So therefore, there are opportunities for patent filings based on a meaningful limitation that's in the patent application that goes beyond just linking the use of an abstract idea to some technological environment. You can't just say, oh, this computer is just going to do this in this particular area. It has to actually link and come up with a meaningful limitation as to how the function and how the technology is being used. And another way of saying it is a technological solution to a technological problem. So a technological problem being that you need to be able to do, using AI, process an immense number of amounts of data. Now, in order to do that, yes, you can have a computer sit there and go through the data just like a person would sit there, and yeah, the computer would do it faster, but argument could be made that a person would be able to do it also in 150, 200 years if they sat there working on it. But the AI side would have, if it has a technical solution to going through this data and being able to do it in a way that, let's say, instead of using the processor at 100% of many supercomputers, now it's using one supercomputer and the processor is only working at 40% of its capacity. So some reasons to file for patent protection. Patent protection can be an important part of overall business strategy in a global market. I think that sort of speaks for itself. Software patents do add a lot of value to a particular industry and to a company, especially ones that are looking for funding, or ones that are looking to have a defensive mechanism for having a number of patents granted in order to ward off any other companies or competitors who might be out to sue them for a patent infringement of their patents. Now, one thing that's happened recently, as I'm sure everyone is aware, the pandemic has accelerated how software and software innovation, AI, is involved with everything. Everyone's working from home, but aside from that, it's put a lot of pressure and a lot of forced a lot of innovation out of that area for human beings to figure out, how do we do a certain thing that humans were doing before, but now we need some AI computer to be able to do this in a more efficient way and make the computer function in a better or a faster way. Now, one thing to point here is about 60% of recently granted patents were all software-related patents, which was a surprise to me and everyone else at our firm when we found this out, because software has such a bad rep. Everyone thinks, oh, software may not be patentable, or AI, there's nothing there to patent. But clearly, the USPTO and the people filing for patents, number one, it shows that a lot of people are filing AI patents. And number two, it shows that a lot of them are being found to be patentable subject matter. And we'll talk about this again, I think, in a couple of slides. But as long as they're novel, unobvious, and meet all the other criteria, they could result in a granted patent and provide patent protection. And again, another reason to file for patent protection, given that right now it's all about the Internet of Things and this digital transformation where everyone's going to be living on the metaverse. It is important to stay ahead of the competition and file for patents in that area. Again, whether it's AI specific or if there's AI related software applications, it's important to file. Otherwise, competitors perhaps might be filing as part of their R&D and as part of their company strategy. So timing considerations of filing a patent. The US switched to being a first to file system about, I think also about eight, 9, maybe even longer, 10 years ago. Whereas before, people could prove that they were the ones that came up with the idea first, and then they invented a particular invention before someone else, that they could show lab work, documents sent internally within the company. They now have the first to file system where you have, the only option is to file first. And so there's going to be a way to sort of this rule of thumb is file patent applications before any sales, offers for sale, any disclosures, which could hinder or actually destroy patent rights. These two things go together. The timing goes hand in hand. Being first to file is important because you beat other inventors to the punch, or in the race, as the picture shows. And also, you get a chance to file your application before you make any disclosures, which could start the time or the clock running and potentially make you lose any patent rights in some jurisdictions. The US does have a 1-year grace period from when you disclose an invention to when you file a patent application. But a lot of foreign jurisdictions, for example, Europe, if you disclose anything and then file for a patent application, that disclosure can be used against you as prior art, even though it was your own. And therefore, you lose your patent rights, and it destroys the novelty. So one phrase that's been said a lot since the first to file system is to file early and file often, meaning that file your patent application as early as possible and as often as possible. So a couple of more things to go over as far as patent filing strategies are concerned. The file early and file often, obviously, budgets are an issue. A lot of companies don't have unlimited budget to just continuously file patent application as often and as early as they need. So provisional patent applications have become a very big tool, an important tool in allowing such companies to protect their IP, specifically their patent inventions. And so provisional patent application, as it says here, is a low cost and efficient way to get an early filing date. So as an example, if someone wants to disclose an invention or offer it for sale or advertise it, it's very important, and it's advisable to file a provisional patent application because they take less time to draft. Their cost is a lot less than the full-blown patent application, and it provides them a 12-month window for not only perhaps developing more specific details about that invention, but also it gives you 12 months to decide whether or not you want to pursue that patent application. So an example I always give clients is, during those 12 months, a lot of things will become clear. That's a year is a good amount of time to know whether a particular product is successful and it's worth pursuing patent protection for it, or it's something that should be let go and not pursued any further. Again, the good thing about these provisionals is they do expire after, well, the good thing is that they don't become publicly available. So if they do expire at the 1 year mark, no one can look it up in a database. It doesn't, the USPTO does not disclose that anywhere. And therefore, if it was something that the company or the inventor decided not to pursue, it wouldn't become part of the public domain where someone can pick it up and be like, well, they didn't get a patent on it. I'm going to use it, and I'm going to get a patent myself for it, or I'm going to build a product off of it without the chance of getting sued. So the provisional patent applications are, like I said, useful, quick filings to secure the filing date, give yourself more time to decide the lay of the land and figure out if that's something that should be pursued further or not. And if it is decided to be pursued further, a non-provisional patent application can be filed that claims priority to that provisional application. And this non-provisional application gets examined. Now, it's a lot of companies to this day still only file non-provisional patent applications as a starting point. That's because maybe they've had enough time. They know there's enough time before any disclosure, and it's more important for them to just file a non-provisional and have everything done initially because they know it's something they want to pursue. So it's not necessary that you have to file a provisional. A provisional is sort of gives you a half of a step that you can take before you take the full step in order to make a determination as to whether you want to take the full step or not. And so when a non-provisional patent application goes in front of the patent examiner, there's 5 requirements that it needs to meet in order to get granted into a patent. And then I alluded to some of these before. We discussed patentable subject matter and as far as AI and software and how they tie in with being able to make sure it's not an abstract idea and that it's improving a technological area or solving a technological problem with a technological solution. The patent has to have a utility. Software, it's not usually a problem. Most of the time that's clear, there's utility. Then there's novelty. Obviously, it has to be novel. Non-obvious, meaning that if looking at 2 different applications or looking at a product and another patent application, the examiner does not think it would have been obvious for someone to combine those 2 together and come up with the same idea as the particular patent, the idea that's being disclosed in that particular patent. And so obviousness is actually one of the harder rejections to overcome, but it's doable. There's a requirement for an enablement, which means that the patent application needs to enable someone similarly skilled in the art to be able to make or build or perform the same as what's being disclosed in the patent application that's being granted. So again, as long as specific to AI, we've talked about the patentable, how to make it be part of the patentable subject matter. They have utility. If they're novel, again, UI is such a new field that there's still a lot of novelty out there. And as long as it's not obvious and the patent application enables someone else to be able to build the same, let's say, AI structure, then it would qualify for patent protection. And lastly, I'll just talk a little bit about a patent portfolio management. So for people that work for a company that wants to or has a patent program, or they want to start thinking about how to build a patent portfolio, there's some structure to this where there's some principal categories to follow. Obviously the first step is identifying inventions as inventors bring them up and figuring out what inventions, what products should be pursued for patent coverage. This is a very informal way, and I've sort of coined this, where I tell my clients, if your engineers had to get together in a room, in a conference room, or now in a Zoom conference room, and get on a whiteboard and figure out a way around a particular problem. So if they hit a bump in the road, and it's not just, oh, we'll call this API um, from this other third-party software, and we'll just add this thing here and do that, and we'll get the results we want. If it goes beyond that, where they have to get together and figure out, okay, we need to move the data from here to here. Let's split up the data. Half of it should sit at the cloud, half of it should sit down here. And then we'll be able to bring them back together for a final, solution. That's when you know that you've entered into the patentable invention, something that should be pursued for patent coverage, because now you're spending time, effort, brain power to come up with a solution to a problem that you face. And most of the time, again, with AI and software, it's a technological problem that's come up where you're running your code and it's not working. You have to figure out how to get this thing to work. And so getting together and as a team or even individually and figuring out how to solve that problem, how to overcome that bump in the road, that's when a light bulb should go off and indicate that there could potentially be some patentable ideas there. Then the next step would be preparing of a patent application. A lot of inventors write up an invention disclosure form and work with their patent attorneys to provide those. Our firm does very similar things. We also do a lot of video conference calls with inventors, go to the inventors if possible, sit with them, interview them, take a half hour of their time and go over some of the details and just ask them the right questions and get them to tell us what really is at the heart of the invention. And then the patent prosecution side, which is what the patent attorneys would do with the patent office, meaning that once the patent has been filed, the examiner has looked at the patent application, and now the examiner has some problems with it or found some prior art that we need to distinguish by making arguments and showing the patent examiner why our invention is different than the prior art, and perhaps changing the scope of our the claim to the invention, meaning as opposed to having our invention cover a broader area, we make it more specific and add some specifics to it or limitations that are not covered by the prior art, and say that that's where the difference lies between our invention and theirs, and that's why it should be granted into a patent. And then the last step would be just a patent program administration and maintenance. There's maintenance fees that need to be paid for patents. It's pretty low at the 3.5-year mark, gets a little higher at the 7.5-year mark. And then when you get to 11.5 years, it's pretty expensive, but it's worth it for people that by that point, they know that their patent has value to the company and to them. So it's part of the maintaining of the patent, because the USPTO and the government, they don't want people to get a patent and sit on it. Their goal is that people use it to innovate and continue thinking that they have patent coverage, and to continue the ability to improve on it and make more improvements and make it a building block to more innovation, and therefore, yeah, so maintenance fees are required, and there's administration of patents and making sure everything is accounted for and all the deadlines are met. And with that, I thank everyone for their time. Hope that was useful information, and it gave them an idea of where AI, data science, and IP kind of meet. I will add, just this last Wednesday, the USPTO had a stakeholder meeting where they asked a lot of professors, prominent patent attorneys to give their input as to where they think AI fits in the patent system. It's kind of a fluid new area of law. There is not a whole lot of case law and therefore the patent office is still trying to figure out its direction and provide more clarity as to what an AI particular specific patent application should look like, and what AI should really deserve patent protection, and what AI does perhaps does not.